Good afternoon, everyone. My name is Renee Thompson. Thank you so much for joining us for this special joint webinar. I am chair of the Solo and Small Firms section, and I'll be moderating this free CLE today along with my co-hosts. Lyra, I'll go ahead and let you introduce yourself.
Hi, good afternoon, everyone. My name is Lara Davide. I'm the immediate past president of the Caribbean Bar Association. I am located in Miami, Florida.
Vanessa?
Hi, everybody. I'm Vanessa Vasquez Delara, and I am the chair of the Miami-Dade Solo Small Firm Committee, and I practice family law in Miami.
And Dwayne.
Good afternoon, everybody. My name is Dwayne Robinson. I'm a partner at Kozak, Trope, and Throckmorton in Miami. I'm here today on behalf of the Wilkie D. Ferguson Junior Bar Association, the historic and largest association of Black attorneys in Miami, and I'm in Miami.
Fantastic. We're so grateful that you all are with us today. We are going to be presenting with Davide Proietti, I hope I said that correctly, on Corporate Transparency Act and what law firms need to know before the end of the year. It's a very timely topic and a very important one, so we're grateful that you all are on here. Just a few housekeeping matters. The audio feature is turned off for participants. So if you need to ask a question of the speaker, we'll try to take some at the very end. But if you have any technical issues or if there's something that you need to reach us about, you can use the Q&A function and I'll be able to monitor that and to see it. As I stated, our speaker today is Davide Proietti. He is based in Miami, Florida at the firm of Marko and Magolnick, PA, which has been there for over 30 years. Their firm handles business transactions and litigation, and he specifically focuses on commercial and corporate transaction work. So we're so grateful to have you. I'm going to turn the mic over to you if you want to just unmute and share your presentation. We'll go ahead and let you get started, and then we'll join you all back at the end.
Thank you very much, Renee, and everybody for allowing me the opportunity to present today. Let me share my screen. Okay. Okay, so as mentioned, today's presentation is about the Corporate Transparency Act. This is a new federal law that touches on many small businesses. And as we'll see later in the presentation, the deadline for reporting is quickly approaching. So it's important to share information about the Corporate Transparency Act and its requirements, because in one way or another, it touches all of us as, in some cases, small business owners or as attorneys with respect to counseling our clients. Today, we'll talk about the CTA, sort of the background, what led to its enactment, the purpose of the act and its effect. We will address key compliance timelines. As I mentioned, one of them is December 31st, which is coming up very quickly, right around the corner. We will go through a relatively simple flow chart involving 4 steps to determine first, whether the company in question is a reporting company or if it's subject to any exemption. 2, figuring out the beneficial ownership of the company and the applicant identification. We will get to the details of all of that as we navigate through the presentation. 3, identifying the information that needs to be reported once we've figured out the reporting company, beneficial owners, and applicants. And 4, monitoring for ongoing updates, again, in compliance with the applicable timelines. We will look at a beneficial ownership information example and discuss a few important takeaways from the example. We will talk briefly about FinCEN IDs, what they are, how to use them, and how they can help us sort of shortcut some of the paperwork involved in the reporting. We will address mini CTAs. The S is in parentheses because for now there's only one state level enactment of a law similar to the Corporate Transparency Act, but never say never. Other states may follow. And finally, we will discuss some practical implications of the Corporate Transparency Act and sort of how it has impacted or changed in some ways the way in which we represent clients and go about internal record keeping for our own firms. So what is the CTA? As I mentioned, it's a new federal law. It became effective on January 1st of this year. Essentially, the Corporate Transparency Act requires a vast number of privately held entities, primarily small businesses, to report beneficial ownership information, abbreviated as BOI, to FinCEN, the Financial Crimes Enforcement Network, which is effectively the enforcement arm of the Department of the Treasury. The information that is reported to FinCEN must be maintained confidentially. It can only be disclosed to certain governmental authorities in connection with law enforcement purposes or some financial institutions in relatively limited circumstances relating to, again, law enforcement, investigations, and compliance-related matters. The typical basic example is opening a bank account. The bank is doing their KYC with respect to a company to make sure that the financial institution is not opening a bank for an entity that is controlled by, some bad actor, money launderer, tax evader, international criminal, or something of the sort. The reporting of beneficial ownership information can be done online directly on FinCEN's website. I reported the link right there. I want to spend a second to address this because if we just go online and as many of us do, we just Google FinCEN BOI reporting, we will get an avalanche of results of advertisements of private companies that are offering BOI filing services. So what these companies do, at least the ones that I've checked out, is that they essentially provide, let's say, a friendly user interface to prepare a BOI report, and then through the use of APIs, of data connection systems, they use the information that the user inputs in the user-friendly application and relay that information directly to FinCEN in connection with the filing of the BOI. Typically, these companies charge about a couple hundred dollars to provide the service. But I want to spend a second to talk about its real value, because if you feel comfortable doing that type of exercise and reporting that information because you know the information that you have to report, I guess my recommendation is that you might as well save that couple $100 and just do the filing for free on the FinCEN's website. On the other hand, if you're not sure about what information you need to report because maybe you're dealing with a more complex corporate structure, or as we'll see, you're not quite sure whether certain people meet the definition of beneficial ownership, then these services don't really provide a lot of service to you, because a lot of value to you, because they don't really explain what information needs to be reported. So again, filing online for free directly on the FinCEN's website. Filing can be done through a web browser or through a PDF form that you download, fill in, attach the required information to, and then upload to the FinCEN's website. I have done both of the applications for different clients. I highly recommend, if you have a working stable internet connection, do the online web-based application. It is much simpler, faster, more streamlined. The PDF form, although it may be, friendlier for some of us to look at because it's a more familiar format, it actually requires, it has a lot of requirements in terms of file naming conventions and size limitations and type of attachments that can be included. So it's not as easy as it may seem. It's actually a little bit clunky in terms of processing of the filing. Why do we have this sweeping new law? Well, for a number of years, there has been actually an international effort to sort of move towards greater transparency in connection with entity formation and ownership and control. As many of us know or have heard, many companies, domestically and offshore, are used or may be used by bad actors for illicit purposes. And so in light of all of this and in light of this global effort to move towards greater transparency, the United States Congress identified the need for a federal law that would impose requirements of disclosure of beneficial ownership information, which, as we will see in the next few slides, encompasses not only actual ownership, but also different ownership-like relationships, as well as decision-making power and control over the entity. So again, as you can see from the sense of Congress from the slide, the point of the CTA is to sort of identify who's behind certain entities in the United States, so that we know that the people that either own or control those entities are legitimate business people conducting commerce in the United States in a legitimate way, and that the entities are not being operated for some nefarious purpose. The text of the law, well, the intent of the law is for it to have a broad application, and the text of the law reflects that intent. The Small Business Administration estimates that there are approximately 33 million small businesses in the United States that would be covered by the Corporate Transparency Act. Congress estimates that approximately 2 million new entities are filed each year that would fall into the scope of the Corporate Transparency Act. And so this means effectively that by December 31st of this year, FinCEN is going to receive something around 35 million beneficial ownership reports. That's a lot of information. It's a lot of reports that FinCEN will be swimming in for quite some time. And we're not really sure about FinCEN's ability to process the sheer volume of information and what they will do with it in terms of enforcement. As we'll see, there are some severe penalties associated with failure to timely file, filing incorrect information in connection with BOI reporting. And so it will be interesting to see, since the law is relatively new, sort of how FinCEN goes about dealing with the volume of information received, checking the accuracy of it, and sort of going about the enforcement in cases of violations or non-compliance. Another interesting point that's sort of related to the enforcement aspect of the CTA is the potential for interagency communication. Now, the Corporate Transparency Act, as we said, has been sort of handed off to FinCEN, which is an agency of the Department of the Treasury. But there are other agencies of the federal government that already have ownership information in their possession. To mention one that everybody knows and loves, the IRS knows who owns certain companies because they can see it from your tax return. Now, the definition of beneficial ownership under the Corporate Transparency Act is obviously not exactly the same as the allocation rules for, say, partnerships or the tax rules that would apply to corporations. So there isn't an exact overlap of the two definitions. And so somebody that falls under one definition of beneficial ownership doesn't necessarily fall under the other. But because there is a significant amount of overlap, and because obviously For example, tax evasion in connection with IRS and tax reporting is one of the sort of common objectives and of the impetus behind the CTA. Again, it would be interesting to see over the next few years how different government agencies approach this potential cooperation. As we've been mentioning, the Corporate Transparency Act is intended to have a broad application, and it's written to have a broad application, but there have been a number of cases that have challenged its constitutionality. So a number of business owners and business associations have attempted to enjoin the enforcement of the CTA and have it held unconstitutional. Many of these attempts, in fact, most of them have failed. However, one case stands out. This is National Small Business United v. Yellen out of the Northern District of Alabama. In this case, the Alabama court found that the CTA was unconstitutional, but, and this is an important caveat, it only enjoined the enforcement of the CTA with respect to the companies that were part of National Small Business United, this business Chamber of Commerce-like organization, at the time of filing of the lawsuit. I stress this point because after the decision came down from the Alabama court in March of this year, I remember seeing a number of articles online and getting many phone calls about the fact that the CTA is now unconstitutional, and so now we don't have to comply with the filing requirements anymore. Well, let's be very careful with that, right? For 99.9% of the companies in the United States that were not member of that particular associations, the CTA is still in effect, and we're all still required to comply with it. What's interesting, of course, about this case is that it's been appealed and it's making its way through the courts. Appellate oral argument was held at the 11th Circuit in September of this year. There's no decision on the appeal yet, but if the holding is affirmed, there will be essentially a split in the law among various districts, because very similar challenges have been sort of shut down elsewhere in the United States. And so it will be interesting to see, of course, from a jurisprudence standpoint, how the constitutionality of the CTA gets addressed in the following years. Okay, so timing of the Corporate Transparency Act. We've mentioned that the first deadline is right around the corner. So the general rule in terms of timing is that for entities that existed before the effective date of the act, so entities that were in existence before January 1st of this year, must file the beneficial ownership reporting before December 31st, 2024. So you could file it at any time. You should file it right now if you can, but no later than December 31st of this year. If the entity is formed on or after January 1st, 2024, so if it's a new company, the new entity has 90 days from the date of formation. So this is typically, if you use Sunbiz, because it's a Florida entity, this is typically 90 days from the confirmation of filing receipt. Because we are towards the end of the year, if a new entity, these are two separate rules, so there's no earlier of. So if an entity is formed today, for example, the 90 days would take us into the beginning of 2025, and that is fine. We don't have to follow the December 31st deadline for new entities. We follow the 90 days deadline for new entities. Important note, beginning on January 1st, 2025, the window for compliance is shorter. It is only 30 days after formation. These deadlines are important, and we should all keep them in mind, because as we'll see, they impact the way that we go about forming entities and maintaining corporate documents. Not everybody necessarily forms entities on behalf of their clients or practices in the area of corporate law, but for those of us who do, obviously there's going to be significant changes in the way in which we represent our clients because of how short these deadlines now have become. There's exceptions to some of these deadlines as a result of a number of devastating hurricanes. The FinCEN, in connection with FEMA, have sort of extended the deadline for compliance by 6 months for those businesses in areas that were affected by these hurricanes. And timing is important because if you're late, there's heavy penalties that apply. The penalty is $500 per day for failure to timely file, up to a maximum of $10,000. If the failure to file is willful, or if the filing includes fraudulent information, there's criminal penalties up to 2 years of imprisonment. Of course, if there's other issues in connection with the filing, additional penalties could also apply. But the part that I want to stress the most is the issue of timing, because as I said, the deadlines, especially for new entities, are pretty short and will become even shorter in the future. And $500 a day adds up pretty quickly. So everybody should keep an eye on the calendar. The flow chart and the next few slides are focused on determining who has to comply, what information we need to gather in order to comply, and what information we need to report. Breaking down the statute, we've sort of simplified the process into 4 steps. The first step is to determine whether the entity is a reporting company or if it's an exempt entity. If the entity is a reporting company, then we have to identify the beneficial owners and the applicants. In some cases, we will identify those cases. And then once we have all of that analysis done, we need to gather some information for the reporting company itself, for the beneficial owners, and for the applicant, if applicable, which has to be current and accurate. That information has to be monitored for ongoing updates. As we'll see, updates are required within 30 days of a change in the reported information, so they're on an as-needed basis. But it's important to, be aware of the information that we have to monitor, because again, penalties apply also for failure to file timely updates. First step, determining whether the entity has to comply with the CTA. So the first question that we need to ask ourselves to determine whether the company is a reporting company is the entity formed by state filing? This includes all LLCs, corporations, LLPs, all of the entities that you have to go online on Sunbiz and submit a document to a Department of State in some state in the United States are reporting companies, and they're subject to the CTA. Interestingly, this also applies to domesticated foreign entities. So if you have a foreign company that becomes domesticated or locally qualified or does business in the United States and files a document with the applicable Department of State or Division of Corporations, that foreign entities also become subject to the CTA as a reporting company. Because the definition includes entities that require state filing, other types of entities that do not require state filing are not reporting companies and do not have to comply with the CTA. So this includes general partnerships, which as a corporate lawyer, nobody should get into, but that's a different story. That's for another CLE presentation. Sole proprietorship, same analysis. And then common law trusts, right? So there are certain types of statutory trusts that do require filing with the Department of State. In that case, those trusts would be reporting entities, but your sort of traditional private document trust would not be considered a reporting entity subject to the CTA. The second step in the analysis is to determine if the entity is exempt, because even if you are a reporting company, but the entity falls under some applicable exemption, then it does not have to file a BOI report. So the statute and the underlying regulations provide for quite a number of exemptions. There's 23 in total. Most of them are not really applicable to your, let's say, run-of-the-mill small business. In other words, most of the exceptions apply to banks, insurance companies, financial institutions, public entities that are traded on a stock exchange. But there's three exemptions that are more common. One is for tax-exempt entities. So these are your not-for-profit entities that have received a tax exemption, your 501c3s, charities, for example, or private foundations. But it's important, and we'll get to that in a second, it's important that the entity has a tax exemption in order to qualify for the CTA exemption. Large companies are also exempt. There's a number of requirements, but the one that we will focus more today is the revenue threshold, which is $5 million per year. It's important because obviously financial performance of a company fluctuates. So as we'll see later on, this is an important exemption, and it's a relatively broad exemption. But if you have a company that is right around that threshold, you may not want to rely too much on this exemption, because if the financial results change, now all of a sudden you go back to being a reporting company and you have to comply with the CTA. Another exemption is that for inactive entities. So again, there's multiple requirements that have to be met here, but the idea is that if you have a company that maybe has been dissolved administratively for a long time because it hasn't done any business and it's sort of just forgotten and it hasn't been used, and it doesn't have any real financial or economic activity or substance behind it, FinCEN doesn't care, right? They want the objective here is to track the money and the minds behind the money to make sure that, like I said, we monitor bad actors and make sure that they don't interfere with legitimate commerce. So inactive entities are not required to report. But again, there's a monetary threshold. So if all of a sudden the inactive entity, I don't know, cashes a check or receives a wire for some reason, now it becomes a reportable entity again. And so those are exemptions that vary or may vary on a whim, and it's important to keep that in mind. Step 2 is determining who are the beneficial owners. Now, the definition of beneficial owner is very broad, and it's more expansive than just ownership. So it includes people that own or control 25% or more of the entity in terms of vote or economic rights. It includes, as I mentioned before, equity-like arrangements. And it also includes people who exercise substantial control over the entity. Of course, it's not that simple, because the definition is extremely broad and it includes catch-all language. So there's a number of sort of hybrid instruments and relationships that, because of the breadth of the definition, would fall under it. And so, for example, if you have an entity with multiple classes of ownership, you need to do a more detailed analysis of how to calculate the 25%. In cases where you have distribution waterfalls in LLCs or limited partnerships, where you may have financial, oh, sorry, something happened with the screen sharing. Okay, we should be back. Sorry about that. And now you know it's live. So in cases where you have a waterfall of distributions, like for example in LLCs or LLPs, priority of distributions or different capital contributions also affect the 25% calculation. Convertible debt, convertible notes, warrants or options. So these sort of contractual rights to equity in the future are interesting sort of hybrid instruments, because they fall in the calculation of beneficial ownership, profit interests, and then, as I said, there's a catch-all, any other instrument that is equity-like or provides equity-like benefits to the holder must be taken into account to figure out the definition of beneficial ownership. Management is equally as broad. So obviously it includes the key executives of the company, all of your C-level executives, CEO, CFO, COO, chief legal officer, right? So general counsel in a lot of companies is a reportable beneficial owner under the definition of the CTA. Major decision makers, people holding a power of appointment or golden vote, even though they don't have any ownership right or don't participate actively in any decision. But if they have a veto power, for example, they could be considered beneficial owners under this broad sweeping definition of beneficial ownership. Because the definition is so broad, I thought it would be useful to go through an example to see the practical applications of how to navigate the definition. So this is an example that's taken out of the FinCEN Small Entity Compliance Guide. It's a publication by FinCEN that is really useful in sort of summarizing all of the requirements of the CTA. It's available online on FinCEN's website. I encourage everybody who needs to report under the CTA to review it. If you're not sure whether you have to report, again, review it, because it sort of takes you through the process, the same process that we're discussing today, but it takes you through the process and it provides some examples like the one that you see on the screen. In this case, this example is interesting because it provides for a layered ownership structure of a company. So you see you have your reporting company at the top. So we're sort of assuming that this is a reporting company formed by estate filing and not exempt. We're already past that determination. It's a corporation, so it has stock as its instrument of ownership, and it's assumed that it's only one class of stock. So it's a relatively simplified calculation in that sense. But there are two levels of ownership because the reporting company is itself owned by company Y and company Z. So two sort of intermediate entities. And then you have individuals behind company A and company Z that hold stock, not directly in the reporting company, but indirectly through their ownership of company Y and company Z. So who is a beneficial owner under the CTA definition of beneficial ownership? Individual A is the CFO of the entity, of the reporting company. Frankly, with respect to individual A, our inquiry could stop here because being a chief executive of the reporting company, we already know that that's a beneficial owner under the definition of the CTA, and we have to report information for the CFO. However, we can also do an ownership analysis, and so we calculate the absolute ownership percentage in the reporting company. So individual A owns 50% of 30% in the reporting company through company Y. So that's a 15% indirect ownership. And then individual A is also an owner in company Z. Through company Z, individual A owns 50% of 25% in the reporting company. So through company Y, individual A has a 15% indirect interest, ownership interest in the reporting company. And through company Z, individual A has a 12.5 indirect ownership interest in the reporting company. If we add those two together, we get to 27.5, if the math serves me right, and that takes us above the 25% threshold for reporting, which means that also under the ownership test, individual A is a beneficial owner whose interests are reportable under the Corporate Transparency Act. As I said, the inquiry for individual A could have stopped at its title, at individual A's title, because as the CFO, it should have reported anyways. Individual B, we do the indirect ownership analysis. Individual B only owns its interests in the reporting company through company Y. So through company Y, individual B owns 50% of 70%, which is a 35% in indirect interest in the reporting company. We're above the 25% threshold, so individual B has to be reported as a beneficial owner. Individual C, CEO and president of the reporting company. Again, red alert, bells go off in our mind. He's a chief executive and key decision maker, so his interest has to be reported anyways. If we do the ownership analysis, we see that individual C only owns 50% of 25% in the reporting company. So individual C is below the 25% reporting ownership threshold, but because of individual C's decision-making role in the reporting company, individual C has to report. Individuals D and E have 50% of 25% each, so 12.5% indirect interest in the reporting company. They do not have any major executive decision-making role or authority within the reporting company. They are below the minimum reporting ownership percentage threshold. They do not have to be reported. Individual D and individual E are out. Lastly, individual F directs important decisions through board representation. Individual F is a member of the board of the reporting company. Individual F does not have any ownership connection to the reporting company, but because of the important decisions made at the board level of the reporting company, individual F also has to be reported as part of the BOI filing of the reporting company. Note, we'll see this in a second, we have done the analysis for the reporting company. Company Y and company Z, if they are reporting companies and not exempt, are going to have to go through their own process with their own, different percentages of ownership in order to figure out who is a beneficial owner in connection with company Y or company Z's BOI filing. So you see how when you have complex or sort of layered corporate structures, the reporting requirements sort of mushroom and grow in size because the analysis has to be applied through every level of ownership. From this example, here's a few key takeaways. The beneficial ownership information report doesn't require you to state the basis for the reporting. So for those individuals that we were seeing in the example that are key decision makers and owners, it doesn't matter why they qualify as beneficial owners, but once they do, you have to report their information. Each reporting company has its own reporting requirements. So again, we did the analysis for the reporting company at the top level, but company Y and company Z are going to have their own analysis, which may or may not be the same. So company Z's reporting requirements may be different from the initial reporting company's reporting requirements because the ownership changes, for example. The BOI report does not require a filer to support an exemption. So if you believe that your company either is not a reporting company or is exempt because it qualifies under one of the 23 exemption, you don't have to go online and file a report or seek an exemption or get a certificate of an exemption. You just have to know it and be really confident about it, because if you're ever audited, you need to have records that substantiate your reasonable belief that you were not required to file a beneficial ownership information report. So the recommendation here is keep really good records. We talked about this briefly. Large operating company and inactive company exemptions may suddenly change based on the volume of company activity or the fact that there is some company activity. So keep that in mind if you are qualifying under one of those exemptions to, be aware of any potential changes in economic performance. Bar associations, since we're on the topic, sometimes if they have a tax exemptions, would qualify as exempt under the CTA as well. However, a not-for-profit entity, which is typical for a voluntary bar association to be a not-for-profit entity, but a not-for-profit entity that does not have a tax exemption would still be required to file a beneficial ownership information report. So it's an important difference, sometimes sort of understated, because one might think that a not-for-profit and tax exempt is the same thing, but it's two separate designations, and the CTA treats them differently and it applies differently. Erring on the side of caution, this is what I recommend to all of our clients. There are severe penalties for underreporting or for failure to report, but there's no penalty for overreporting. So if you have an owner that, is at 24.9% ownership, but then they have some right of first refusal or some golden vote, or they have a significant impact in the decision making of the company anyway, so you're not sure if you should report them, if they don't fall under the definition of beneficial owner, report them anyway, right? Remember, these are confidential records kept by FinCEN. Now, yes, there could be, in theory, some security concerns about personal information, names, addresses kept in a government secure database. What if there's a security breach, cyber criminals, all of those sort of unpredictable things that we all know could happen in the 21st century. But in terms of strictly looking at the compliance requirements, my recommendation is, if you're on the fence about whether a particular individual is a beneficial owner, and there isn't really a meaningful reason why you shouldn't report the information for that individual, then err on the side of caution, report them anyways. There's no penalty for it. Company applicant. This is an interesting step in the determination of reportable information, because the definition, I am realizing over time that it confuses people often. So entities that are formed on or after January 1st of this year are required to disclose the company applicant. If the entity is an existing company, this requirement does not apply. Who is the company applicant? It is not the person who's filing the beneficial ownership information report. So if I go online and I'm filing the BOI report for my entity, I'm not the applicant, or not necessarily. The applicant is the person who files or prepares for filing an application to form the entity, right? So this is the person or people that have prepared the documents to be submitted to the Department of State for the incorporation, organization, formation of the company when the company was born. It includes professionals. So if you, as a lawyer, are forming entities for your clients, you are an applicant, and your information has to be reported by your clients. It includes individual preparers of company formation services. So if one of our clients hires LegalZoom or some other company formation service, the actual individual at LegalZoom that prepares the report and files it on behalf of the client is the applicant. So I'll talk about this a little bit further later on, but this is starting to come up because as the deadline for reporting approaches, and there's new entities being formed in 2024, and many of them continue being formed by company formation services, clients now have some trouble going back to these entities and spending hours on the phone with the customer service representatives, because they're trying to figure out who it is that they need to report as the company applicant, who was the individual who had sent and filed the articles of incorporation or organization with the Department of State. So important to keep in mind. For each applicant, the reporting entity must disclose full legal name, date of birth, residential or business address, a residential address of an individual. If it's done through a company, it could be the business address where the individual did the filing. and then a unique identifying number from a valid state-issued ID or FinCEN identifier. We'll talk about that in just a few minutes. Once we have identified that the entity is a reporting entity, that it's not exempt, we know who the beneficial owners and, if applicable, applicants are, then we file a report. What information do we have to include? For the company, name, federal tax ID, and address of the principal office. Name includes, of course, any DBAs or AKAs or aliases of the entity. For the applicant, if applicable, name, date of birth, address, and current ID, including you must upload a photo of the ID. For each beneficial owner, the same information that is required from the applicant, including their IDs. If owners are from a foreign country, then a copy of the passport, as long as it's a current, valid, state-issued ID, then it will work. Interestingly, if an entity that is a reporting entity is, for example, owned by an exempt entity, even though that exempt entity is the beneficial owner, there is no reporting information required beyond just the name of the exempt entity. In other words, because the entity is exempt and wouldn't be required to report its ownership anyways, its subsidiary reporting company will only report the name of the parent as an exempt entity. If this information that is reported changes, updated BOI reports must be filed within 30 days of the date of change. There's some pieces of information that may change sort of involuntarily. Promotions or demotions within the company. Somebody becomes the new CEO and the old one leaves. That's a reportable change of a person with significant control over the entity. Contingent transfer triggers in connection with ownership. If somebody dies, it goes through an estate. If somebody exercises their option and buys out everybody else, these changes of ownership that may or may not be known to the lawyer who's representing the client could trigger an obligation for the client to report the updated beneficial ownership information to FinCEN. Name or state change for the driver's license or state issued ID. If people move and they go to another state and they get a new license, and that new license has a different document number, that new license must be reported as an update to beneficial owners' information. So we've mentioned FinCEN IDs a few times during the presentation. What are they and how can we use them? How are they useful to us? FinCEN IDs are unique identifiers issued by FinCEN for the purpose of BOI reporting. You can apply for a FinCEN ID by going online on the FinCEN's website. There's a separate link. You provide the same information that you would provide if you were reporting yourself as a beneficial owner, except that at the end of the process, you don't get to the filing of a BOI report, you get a number, which is the FinCEN ID. When is it useful? Well, let's say that you have a person who sits on multiple boards or owns many different companies, which are reporting entities. Instead of every time putting the name, address, date of birth, and a copy of the document for that person, you could have that person apply for a FinCEN ID, and then you just plug in the number each time to simplify the process. Notably, if there are changes in the information relating to that beneficial owner, you need to update the FinCEN ID. So if that person changes the driver's license, for example, as we said, then that person has to go online on the FinCEN ID page and reflect those changes in connection with their FinCEN ID. Mini CTA, maybe CTAs, plural. So currently there's only one state, the state of New York, that has enacted a state version of the Corporate Transparency Act, which is the New York LLC Transparency Act. It is very similar to the CTA, except for 4 key differences. One, it only applies to entities that are registered in New York or that do business in New York with a local registration. Initial reports are due by December 31st, 2026, so there's still some time. It requires reporting and certification of an applicable exemption. So remember how we said the CTA, you just keep good records and don't file? For the NYLTA, you do have to file and substantiate the basis for the exemption. And then interesting about the New York version of the CTA is that the information is also confidential, but may be released by court order. In the case of the CTA, it cannot. So this is going to be interesting again to see how sort of the law develops around this in the future, because let's say that you're a judgment creditor and the judgment debtor is in New York, or it's a New York-based LLC. Does that mean that now you can obtain a court order to, you know, have disclosed to you the beneficial owners behind that entity if you want to try to pursue like fraudulent transfer claims or you know, pierce the corporate veil or whatever other theories. Not sure. We will see what happens after 2026. Like the CTA, the New York mini CTA applies penalties for non-compliance, which range from fines, deactivation or dissolution of the entity, all the way through criminal prosecution and attorney general investigation. Practical implications of the CTA. So obviously this is a new law, big changes, affects a lot of small businesses. Small businesses often don't have all the resources necessary to keep up with changes in the law timely. And so how does the CTA affect us as I mentioned at the beginning, as business owners and as counselors for our clients? First thing is to educate clients and our own employees. So everybody should know about the Corporate Transparency Act, what it is and how to deal with it. Even though not everybody may be interested in listening to 1 hour worth of CLE lecture about the CTA, it's important to at least tell people that, hey, there's a new law that requires you to report certain information about yourself and your company. Look it up, ask people, call your lawyer. Internally, with respect to employees, it's important to develop policies and, you know, record keeping procedures to make sure that, let's say you have a law firm with multiple owners, and those owners, you know, those partners, those shareholders would qualify as beneficial owners under the broad definition of beneficial ownership of the CTA. You need to make sure that you have some policies in place in connection with obtaining their a driver's license. Make sure you can reach out to them and get the information that you need. In connection with our relationship as counselors with our clients, we may want to review our engagements. For those of us who provide corporate commercial advice to our clients, we may want to limit the scope of the engagement or expressly exclude CTA-related matters in connection with the engagement. Imagine a client comes to you, says, hey, can you form a company for me? And then sort of assumes that you would take care of the CTA reporting for them and monitor those deadlines. If you don't plan on doing it automatically, then, you know, best practice would be to disclose it explicitly to your clients. What information can you rely on? Should you be indemnified by your clients if they make mistakes? If you're the applicant forming the company for them and they feed you incorrect information about the company, is it your fault? Or should they sort of pay the price for it? Who's responsible for monitoring updates? How do you monitor updates as an attorney for your client if the client doesn't actively or proactively tell you about changes in the entity? How do you disclose that to your client? Again, in the wave of sort of disclaiming responsibility for certain aspects of the engagement and limiting the scope of work. If you are drafting corporate documents or commercial documents for your clients, obviously there's significant implications in connection with, you know, shareholders agreements, operating agreements for those entities. There's a number of additional clauses that you would want to consider regarding the CTA, compliance, provision of documents, communication, requirements for updates, maybe internal penalties for non-compliance. In other words, if you don't give me the documents timely and the entity is subject to a CTA penalty, the entity will not make further distributions to you until that penalty is paid off. So there's a number of provisions that can be included in sort of governing documents for the entities. Of course, there's additional implications in connection with commercial documents, contracts, opinion letters, and so on. And then the biggest change is going to be in the formation process of the entities, because it used to be the case that people could just form an entity and leave it on a shelf without disclosing ownership or management information for future use. Now you can't do it anymore. You have 90 days, and beginning from 2025, it's going to be only 30 days. So it's important to know exactly who the owners and managers are, obtain information about the entity early in the formation process, get the EIN for the entity early in the formation process, and gather all the required documents. Thank you very much for your attention.
Thank you so much, Davide. You did such a great job sharing all this important knowledge with us at just critical times with all of these deadlines coming up. We so appreciate you participating. This webinar, of course, is brought at no cost to the participants by a number of the organizations that are present here today: the Solo and Small Firm Section, Miami-Dade Bar Solo and Small Firm Committee, the Wilkie D. Ferguson Bar Association, and the Caribbean Bar Association. We did have a few quick questions, but before I go into those real briefly, for those of you who have sought this out for CLE credit, you will need to log into your Florida Bar Member portal to enter your CLE credit. It's been approved for 1 credit, including business litigation certification. And that number is 8799 for this course, 8799, which we also put on our promotional slides so that you're aware. We did have just a few quick questions. I'm going to try to get through these. If there are no changes to the BOI, does someone still need to report every year?
No, it's not a yearly requirement. It's just on an as needed basis, depending on updates.
Okay, can a report be amended if a company applicant did not report something correctly?
Yes, it can. It can be amended, supplemented, or corrected. There's a timeline to do that. It's 30 days. There's a safe harbor for sort of unknown mistakes that are discovered later on of 90 days from the date of the original filing of the BOIR. It's a known or should have known standard, so keep an eye out, make sure you monitor the information.
Okay, and the information that's required, I think you went over that in one of the slides, but if you want to just talk about briefly what an attorney might want to gather in order to file.
So in terms of once we've identified the beneficial owners, what they have
Yes.
to report? Okay, so name, address, and a copy of a government issued ID. Driver's license is perfectly fine. Photo for the upload. And if there's a foreign owner, then that does not have a US ID, then a passport photo page is sufficient.
Okay. If an LLC has been administratively dissolved in the year of 2024, does it still need to file if it's considered active as of 1/1/24?
Maybe. It depends.
That's okay. I
Yes,
encourage them to reach out to you separately if they have more questions about that. That's fair.
yes, there's a 3-part test, and it's not automatic that just because it's been administratively dissolved, it meets the requirement of the inactive entity exemption. So maybe.
Okay. Did you say that insurance companies were exempt?
Correct.
Okay. If you have a dissolved company on SunBiz, do you have to report? I think that's kind of what I just
Same
asked you.
answer as above.
Yep. If an LLC has 4 members, where, there's a credit union that has 79% ownership and individuals that have 7% ownership, do they still have to report BOI?
So you would do the analysis of whether each individual is a beneficial owner independently. In other words, you would look at the entity, sort of follow the steps mechanically, and then see if that owner has to be reported or not, depending on the ownership, on the decision-making authority, other special rules that may be applicable. off the top of my head, it's kind of, I have some difficulty in sort of doing it on the fly, but I'm happy to answer questions separately. If anybody wants to reach out to me via email or phone.
Okay. And then what is the penalty for a company that does not report within the 90 days if it's been established in 2024?
It's the same penalties for the late filing. So it's $500 a day up to a maximum of 10,000. And if the violation is willful, it may include criminal penalties. Again, we don't really know how FinCEN will enforce and how harshly they will enforce it, because there's a lot of people that still just don't know about it. So it's important to do these seminars and outreach programs, because there's significant violations and probably not a sufficient amount of information about the CTA.
And do you know if the Florida Department of State noticed corporations about these requirements for small businesses and law firms? I know some folks had some questions about better proper notice from them. I don't know if you know if they did.
Yeah, so they did. They had like a banner on their website, and then in the yearly sort of renewal emails that they send out, which is a plain text email with a bunch of just lines of text, one of the lines said, "Oh, by the way, you can go to jail if you don't do this thing." Which, again, could it have been something more substantive and in your face? Yes. Did they technically comply with the requirement to let you know? Yes.
Gotcha. And then we'll try to get in one last question here. Is there a dollar threshold for revenue to file? So if an LLC doesn't hit a specific amount, is it exempt?
So you have two, right? So you have the the inactive entity exemption, which is three requirements, but the monetary threshold is $1,000. So less than $1,000 of activity is considered inactive. And then you have the large entity exemption, where the threshold is 5 million or more. So if the entity moves, whether in income or expenses, $1,000 on the low end, and then has revenues of less than 5 million, it's a reporting company.
Okay, fantastic. I hope I hit all of the questions. I think I did. But if for some reason you all would like to share your questions after the program with the presenter, we would be happy to share those with them. You can reach out to us at the Solo Small Firms section, or you can reach out to Davide individually. We want to do our very best to get you as much information about this as possible, but clearly there are going to be individual situations that require distinct information depending on the circumstance. So, with that being said, we've reached our limit for time today. So we just want to say thank you again to all of our hosts and to our presenter. You all have been wonderful. We hope you found this program helpful, and we welcome suggestions for future presentations and future programming. Everyone have a wonderful afternoon. Thank you very much.
Thank you. Goodbye.
Bye-bye.